parents come unglued. Back in the day, when the traditional sexual morality reigned, young girls in college would, in high school would suddenly not come to class anymore, and everyone would go, what happened to so-and-so? Well, after a while, everybody figured out they became pregnant, and they just disappeared. They went off into grandma's house or whatever, or maybe they were shipped out and they had their children. It was always suggested they give it up for adoption. They were too young, yada, 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 yada. And because there could be difficulty at home if a young girl came home pregnant, the court decided that if a judge okayed it, then the child was allowed to abort the fetus. Yes?
What about the abortion pill for like the 24-hour?
Right.
Did you still have to wait instead of
That's a great question, and frankly, I don't know the answer because that prevents conception. So I don't have the answer to that. That would be, I'll look that up for you. That would be interesting. I don't think it would apply here because even in '92 we didn't have that pill. That's more of a recent discovery. But it's a great question, though. I don't think it would apply. Now, there were two other provisions, medical emergencies that exempt a woman from the restrictions if her life is at stake, and requiring clinics and doctors to provide the state with statistical reports on abortions. They just wanted information. They make reports on all of the kind of things. They wanted reports on this as well. Another requirement was turned down, that married women had to first tell their husbands. This was struck down due to what they called an undue burden again. They didn't want to put the woman in jeopardy. Men who batter women, they love to kick them in the stomach when they find out they're pregnant and they don't want to have the child or child support. And the court decided they're not going to place that kind of a burden on the woman. Now, there are 10 states that have ultrasound procedures. Some are optional and others are mandatory. In other words, we're required to show you what the procedure's about, so they put you in a birthing table and they have a live screen up there and they do an ultrasound and you get to see what's inside you. Don't forget, this is designed to dissuade or discourage a woman from having one. It's one thing to look at things maybe in the abstract. It's something else to look at it live on the television screen. Optional for some. In 2 states, it is mandatory. Questions about that? Still, a woman's allowed to have an abortion. We've limited the funding, we've limited the facilities and the personnel, but as long as a woman can afford one or someone will do it pro bono, they're allowed to do it. Now, in 2000, Stenberg versus Carhart, these lawyers who came before the Supreme Court should lose their license. They came to argue against a procedure that was called dilation and extraction. I don't want to explain dilation extraction. I'll do that when I get to the next one in 2007. It's a surgical procedure, and these lawyers came before the court, and they're going to make a medical argument to the Supreme Court, and they decide to use political language instead. At issue is a Nebraska law banning in all circumstances except to save the woman's life. No exception for the health, automatically be thrown out. But that's not what ticked the court off. A rare but highly controversial abortion technique called intact dilation and extraction. The law didn't use that term, it rather used the term partial birth abortion. And the reason it did that is because in the 2nd trimester it's called dilation extraction. They thought if they could get away with the 3rd trimester abortion ruling, they could take it right back to the court with the 2nd. And the court said, do you think we're stupid? You want to have a medical conversation with us? Use medical language. Well, they didn't. The court threw it out. That ticked them off, but what threw it out was it didn't have an exception for the health of the woman, only had an exception for the life of the woman. So it's automatically going to be thrown out. But it really ticked the court off that they used political language when they came to make a medical presentation. Okay, so Carhart doesn't affect the procedure. Then we get to 2007. They come back to Carhart again, but this time it's Gonzalez. It turns out it's Attorney General Roberto Gonzalez. And he realizes the court wants to hear a medical argument, and so he brings them a very interesting medical argument. Okay, so here's our pregnant woman again. This is an argument involving what we call a late-term 3rd trimester abortion. 8 months, maybe up to 9 months. What happens is the fetus, in almost all cases, turns from breech to head first, because we talked about this, the head's got plates up there and it's got, okay. And Gonzalez says, okay, let's talk about this. He says, in order for the critter to move out of the womb into the woman's birth canal, because when the birth canal is breached, we're close to childbirth, which is almost close to being born. What has to happen physiologically to a woman in order to bring the fetus out of the womb into the birth canal? You have to dilate the cervix, and we know how to do that. We can give chemicals, and it goes from nothing to 9. I don't know how big 9 is, but it goes to 9. Say what? You have to have contractions because that's going to move it out of the womb. But what else has to? That's all right, but what else? I'm looking for a very specific thing. Water has to break. You can't bring it in the birth canal without breaking the amniotic. Wait.
No.
When you bring the fetus out of the womb into the birth canal?
Saying, like, you know, like in TV, they're like sitting in the car and they're like, oh, my water broke. That doesn't happen to everybody.
Well, I'm not saying it did, but for this procedure, you have to bring the fetus out of the womb, out of the liquid environment, into the birth canal. They purposely break the amniotic sac, so the water, okay. So, what Gonzalez says in a medical argument, 2 anatomical landmarks, or 2 things body-wise to a woman has to occur. Number 1, we're going to break her water so the fetus can be moved into the birth canal, and then, okay, well, if you go from H2 to O2, Gonzalez says, okay, now we don't know if the fetus is able to breathe, but we know in liquid it's not going to breathe. Now, when you pop out of the oven, the reason they want to sponge you is to get any mucus and anything left, because you have to breathe or you're not going to exist. So Gonzalez says it is possible, having brought the fetus out of the womb into the birth canal, in the absence of liquid, it might be able to take a breath. We don't know, but it might be able to because we're now out of the absence of H2O. What?
Hold on, sir. I mean, I helped deliver all 3 of my children, and I was Johnny Bench on the other side, and I know exactly what transpired when I helped deliver my kids and pull them out. I mean, we're talking fluid from every...
But we're not talking about out. We're just saying the possibility.
Okay, I misunderstood. My apologies.
That's okay. I'll let you be wrong. I'm more than okay with it. That's cool. And then the other thing that happens then is we induce the fetus into the birth canal. And the birth canal is required in order to bring about childbirth, and childbirth brings about a newborn, and this is a person. And Gonzalez says, the whole purpose of this procedure, and this is where it gets a little dicey, I apologize, the whole purpose of this procedure is called intact dilation and extraction. The fetus is going to be intact. There's no cutterage, there's no dismemberment, intact. The whole purpose of it is to bring the head far enough through the birth canal to be able to puncture the head and collapse it. And then intact, the fetus is extracted. And the court said, you mean the only reason you're doing this is that you want to bring it to this point? It's not born. The law's not going to change. And therefore the moral status isn't going to change. But the court says the only reason you're bringing this entity into the birth canal, it's this far away. The whole process is to bring it out. When you do it naturally, you get this far, the rest of it goes. Is to terminate it? Don't forget the court looks at viability. It was always back in '73. And it said the whole point of the medical profession, by its design, is to bring life where it can, not to bring death. And this still has viability. It has life. And the whole reason for doing this is to premeditatively terminate it. And the court said, we're not going to live with that. And so Gonzalez versus Carhart, 2007, this procedure is not allowed. Now, is there wiggle room? Of course there is, for the life of the mother, for the health of the mother. You can make an argument. I think there's only 2 or 3 physicians that do this anymore because it's considered not legal. So they put themselves in a certain level of jeopardy. People aren't willing to do that. They understand the argument here. It's premeditated termination of a life this close to birth, and that would be a newborn, and that would be full moral standing. The fetus continues not to be a human being according to this law. It hasn't been born. But it is so close, and the court says the medical profession doing this specifically to terminate it, they decide they're not going to live with it. Now, if they can do this procedure inside the womb, like they do dilation extraction is dismemberment, and then you remove. The court says that's a woman's right. It's within her body. She has complete control over it. But this specific procedure, they no longer endorse. But it doesn't mean it can't be done. You can take it to court. Take your chances with the court. Any questions about Gonzalez? So the whole point from Roe on has been financially limiting financial access, but not limiting a woman's right. The only exception is Gonzalez versus Carhart. Because this procedure, the only intent of this procedure is to terminate, and it's this close. But the legal status of the fetus does not change. It's not born. The procedure is done while enough of it is still in the birth canal. They do not consider that a live birth. Questions?
So this is not legal?
The court says they do not want this done.
Okay.
Doesn't mean it can't be done. There are a couple of physicians, I think, have been a party to it. And the court's reasoning is, one, it's so close to life. The other is they can't understand how the life or health of the mother at this stage, knowing the woman has been informed and she's compliant with the procedure, that this has anything to do with life or health. I'm not saying it isn't. You can make an argument about anything, but it brings it down to a very tenuous position. And there aren't many physicians who are willing to test this yet. Now, in 2003, we had the Partial Birth Abortion Act. Any physician who in or affecting interstate or foreign commerce, that means if women go across lines, that's considered interstate commerce because people are performing a procedure and getting paid for it, so it's commerce. Knowingly performs a partial birth abortion and thereby kills a human fetus shall be fined under this title and imprisoned for not more than 2 years. So it's not first-degree murder. The statute prohibits a method of abortion that's called a partial birth abortion, yada, yada, yada. Now, Women's Health versus Hellstead, the Supreme Court in a 5-3 decision swept away forms of state restrictions on the way abortion clinics function. This is because in Texas, they decided to pass a law that said in order to have a clinic with a licensed physician perform an abortion, it had to have rights to a hospital. Hospitals are not required to give a physician rights. You can be in a simple surgery and you can almost die from it. So you need to have advanced medical care or access to medical care. What happened in Texas then is a lot of hospitals decided they weren't going to grant rights. So you had, I think, 3 or 4 clinics in the whole state of Texas where the physicians who were performing abortions had rights to hospitals, and the court said that just limits, I mean, it's a big state, that limits access. And so they struck down that. That's what this one's about. State laws regarding Roe. Several states have enacted so-called trigger laws that would take effect in the event that Roe Wade is overturned. States include Arkansas, Illinois, Kentucky, Louisiana, Additionally, many states did not repeal pre-73 statutes, hoping that if it's repealed, they automatically go into effect. They just have to reenact them and bring them up to speed. Everybody with me on that?
What was that about? They didn't repeal?
If they had any anti-abortion laws before 73 statutes, they would just go ahead and reenact them. And they may have to bring them up to certain speeds, but the codes are already there. Now, the biggest challenge, and let me